Hi everyone, welcome back to Clat Possible YouTube channel. And here again, we are going to discuss a topic, a concept which really matters for your Clat examination. Today, we have come up with certain topics related to criminal law. And as you know, that criminal law forms a very essential part of your syllabus. And diverse questions, in fact, questions of variety have been asked by Clat for long time in past years, as we will also see when you solve the past year questions. All right, so let's look at one such concept, that is intoxication. Now, if you are reading criminal law, you would know that intoxication is a defense against criminal liability. That means anybody who says that he was intoxicated at the time when he committed the crime, then his liability may be reduced, or he can be clearly absolved of any liability at all. So this principle says nothing is an offense which is done by a person who at the time of doing it by reason of intoxication incapable incapable of knowing the nature of the act, or that he is doing what is either wrong or contrary to law, provided that, यहाँ से condition start होती है, provided that the thing which intoxicated him was administered to him without his knowledge or against his will. ये दो पॉइंट है जो आपको समझने होंगे कि अगर कोई पर्सन इंटॉक्सिकेशन का डिफेंस लेना चाहता है तो he will have to prove two things. Number one is that there was intoxication that he was not aware of, उसको पता ही नहीं था. And number two, या फिर I mean alternatively, कि जो intoxication उसके साथ हुआ है that was forcible, that was against the will. Okay. Now, what is an intoxication? Simple understanding होती है when a person is high on drugs, drinks, alcohol or any other such substance which creates an artificial state of mind, which creates an alternative state of mind. ठीक है, जिसकी वजह से there is some form of nasha, intoxication is there. That is what intoxication really means. Lekin it is wrong to say that to commit a crime under intoxication is no crime. We can't say that. I mean, you can't make a generalized statement like that. Okay, intoxication is a defense only when you can prove that मुझे नहीं पता था, I had no knowledge, या फिर मेरे साथ फोर्स यूज किया गया था, जबरदस्ती हुआ था, not against my will. Okay. Now, these are the essentials, as you can see. Incapability to know right and wrong. So the third point is the most important point. You will get questions from this part. Let's look at a situation to understand this better. Look at this question, try to solve it. Now, in this question, the principle is same. Nothing is a crime which is done under intoxication, provided that it is without knowledge or against the will. ठीक है, तो हमें यही चेक करना है क्वेश्चन के अंदर. Now A, B and C were having a party in a bar where A persuade किया है, important fact है, to take alcoholic drinks. On the consistent persuasion, again very important fact, B and C also consumed alcohol along with A. B and C had never consumed alcohol before. Now this statement might seem to be confusing, but don't be confused, because this really doesn't have any bearing on the case. Okay, I mean whether a person has consumed alcohol before or not doesn't really matter. And after intoxication, there was some argument between B and C where C pushed B with full force, causing serious injury. So case वही है that a person who was not interested in taking alcohol took alcohol, consumed alcohol on the persistent persuasion by his friend, or we can say based on peer pressure, and then he ended up committing a crime. So should he be liable or not? As per the principle, what is happening is that let's first test whether he had any knowledge that he was consuming alcohol. Then definitely yes. I mean, because ऐसा कोई evidence नहीं दिया है facts में that he did not know what he was consuming. So we cannot assume that he did not know what he was consuming. Such an assumption would be wrong. Okay. Just because he had never consumed alcohol, it doesn't mean he doesn't know what is an alcohol, right? So ये assumption हम ले नहीं सकते. तो knowledge उसको नहीं थी, इसके बारे में कोई fact नहीं है, कोई evidence नहीं है. So we cannot say with conclusion, okay? And again, against the will, क्या ये against the will है? So it might seem like it is against the will because facts में लिखा है कि उसको constantly pressurize किया है, persuade किया है ना, and he is not a drinker in normal sense. But that again is confusing because the answer is that he is liable. Option A is the correct answer. Why is he liable? Because persistent persuasion or a constant persuasion does not amount to unlawful force. Okay, what is the meaning of against the will? If you are carrying a notebook, you must write. It simply means unlawful threat or force. It has to be unlawful threat or force. And what is an unlawful threat? You know, like beating up somebody, kidnapping somebody, threatening of violence, threatening of bodily injury, any kind of harassment, physical harassment. अगर ऐसा कुछ unlawful हुआ है या होने का threat था, only in that case it will be called against the will. लेकिन अगर facts को हम देखेंगे ध्यान से, तो यहाँ पे कहीं ऐसा statement नहीं है that whether any unlawful force was used against him. So understand that peer pressure, yeah, society pressure, pressure by parents, you know, moral pressure basically. Moral pressure does not amount to unlawful pressure, and unless it is unlawful pressure, it is not against the will. That means if you do something under moral pressure, under peer pressure, you do it according to your will. We can say peer pressure, as long as it is lawfully done, is as per or out of the will. ठीक है, यानी कि और अगर कोई पर्सन अपनी मर्जी से ड्रिंक करता है, अल्कोहल कंज्यूम करता है, अपने आप को इंटॉक्सिकेट करता है and ends up committing a crime, then he is certainly liable as per the principle. That's what we have seen. So option A becomes the right answer. Absolutely correct. Okay, I hope this question is clear to all of you with the understanding of intoxication as a defense. Why C cannot be the answer or D? I mean, A की liability हमें क्यों discuss नहीं करनी है? Because the principle does not talk about a person who is intoxicating others. In fact, the principle is talking about a person who is getting intoxicated and committing a crime. Okay, so while option C and D could be independently correct statements or sentences, but they cannot be your answer because the principle doesn't talk about that person who gets somebody intoxicated, but rather than a person who has got intoxicated and is committing a crime. That is clearly Mr. C in this case, right? So the principal has has not provided any information to us for option C and D, and that's why A is the right answer. Since A is the right answer, B naturally becomes the wrong option, and hence this is how we have solved the question. Okay, so intoxication के बारे में क्या समझ में आया कि या तो नॉलेज में नहीं होना चाहिए कि इंटॉक्सिकेशन हो रहा है, या फिर इट हैज टू बी अनलॉफुल फोर्स. ठीक है, नॉलेज में कब नहीं हो सकता? सो मे बी अ पर्सन हु हैज कंज्यूम्ड alcohol believing it to be a glass of juice or something else. He did not know that it contained alcohol, or somebody has mischievously mixed alcohol with his non-alcoholic drink. Okay, so things like that. But ultimately, the test of liability depends on two things: knowledge or will. Okay, I hope it is clear to all of you. For better understanding, go through Clat possible material on criminal law. You will find a lot of defenses there. Read the defenses, read the examples and illustrations, and solve the questions there for excellent clarity on this topic. Right? If you still have any questions, any queries, you can post your questions on the comment box, and I'll be happy to respond to that later on. If you like the video, please like it and share it among your group, among your friends, so that they also benefit from it. And if you have not yet subscribed our channel, please do that, because we are consistent with videos on concepts that really matter for your examination, and I'm sure it's going to benefit you a lot. Thank you so much. See you all very, very soon.